Welcome. How are you all today? I don't know what possessed me to dive into this topic today. We got to go over uh, private placement memorandums. I do know what possessed me to do that. I'll go back. Hold on. What possessed me? What is a private placement? On the options for information, if you research private placement, you'll see Yusef L is promoting a class that he's holding, and he has a co-sponsor to that content, Stephen Brewer, and he is assisting him in um, setting up private placements. And so, in that regard, uh, Yusuf have up the ante as far as trying to learn more in the field of contract law. But I watched that video and it wasn't nothing but pretty much an advertisement for you to buy his class. As you see, he's getting aggressive, and this is not even an aggressive conversation. Let's just kind of go over what was said, what was not said, which deems it necessary to do a more content filled broadcast. Let's get it. Welcome.
Are you getting less than $3,340 in
One
Social
thing got
Security and
two
you're a
doggone
senior on Medicare or
commercials
Medicaid?
with
Here's
this
some
commercial.
fantastic news. They've recently updated their
Had some very intelligent women who came on who had their stuff already arranged and ready to go.
Yes.
You know, and
And Yusuf seemed very shocked that people would have their proper documentation because he's so used to yelling at people and telling them that they are incompetent in some way or another. Um, the problem with that is that uh, anyone who is intelligent will not continue to patronize content wherein uh, the host is berating berating them consistently. This is why I said this content is definitely not informative. It's purpose to engage you enough to perform a call of action to get people to purchase the class that they're offering, which I'm assuming may be a good class because USIP does have very uh, extensive repertoire of information as it relates. It is very what I'm seeing, what I want to say. Mm, uh, Document specific to what your purpose is or what your situation is. You can go to his university, SBC University, online and download the information and be ready to do a lot of reading, okay? Because he doesn't do a lot of explaining other than to tell you you need to read. That's where the breakdown comes in. That's where the real breakdown comes in.
It's very, very interesting, and you provided step-by-step methodology that anyone can see, and they can get that information, and they can see a pathway into actually perhaps monetizing debt or creating some sort of structure for themselves.
Yeah, that was exciting to be able to share this not only to your viewers, but I've decided that I'll start bringing it to the masses because it's really a well-kept secret. However, it's out in the open. And as I was telling the individuals at the webinar yesterday, what triggered my curiosity was in 2008. Like many builders and developers, we went through catastrophe. We lost everything, bankruptcy. I even had personal friends that were lenders that committed suicide. They had extended so much money into the market. And it was just amazing of the effect that the economy had on everybody. But what was so shocking and surprising, as I told the individuals in the webinar, was I'm still seeing commercial units going up. I'm seeing apartment buildings going up. I'm seeing subdivisions going up. And I'm like, how? And that's when I took everything I had to find out how and why. And that led me on my journey is understanding private placement memorandums and capital raises through private sources. And it was truly a kept secret because I would go and try to pull information, pull in the warranty deeds and trying to see who was the lender on these particular transactions. And just quite frankly, it was private information that I couldn't access. And over the years, I've been over this in this industry now, some 17 years, and the stuff that I have learned and I'm learning is all kept secret. And in fact, on one of your previous shows, I told you someone had given me a call after we did the live interview not to share the information. That intentionally is for a select group of people. And I understood what they were saying, but I didn't understand what they were saying because in reality, it's being kept from a certain community of individuals that haven't taken it upon themselves to really dig in and learn it. And so I guess you can say my message to the group on the webinar was, why won't you take these legitimate private structures that fall well within the SEC guidelines and regulations and exceptions, DTC bond structures that individuals can utilize under a regulated section of the SEC rules regulations that allow individuals to create corporate bonds, private bond, entity bonds, and utilize them for wealth. And while many said that when they originally got on the webinar, they were expecting a different twist on PPM, private placement memorandums, on the DTC understanding. And so when I open up their mind to what reality could be for them and their family as it comes to creating generational wealth, they were very receptive to hearing what I had to say. And so that was exciting for me. It really was.
You know, I want to go back and touch on what you were saying about the information being closely guarded and them not wanting it disseminated to the general public. However, after reviewing what you were saying, I think it has its own protection mechanisms already built in. Number one being, are you willing to go through all the necessary steps to achieve this? Just because you have the information doesn't mean it's something that is easy for anyone to do, even if you are provided the roadmap. I think it would be, just even me just listening, you definitely want a mentor to walk along with you with this, man. There's not nothing you want to do on your own.
Well, I have 17 years of mentorship from failure. And I'm creating a master class for a lot of you individuals because they wanted to go further. And I'm teaching 17 years of failure. I've had my successes, but
Hold up. Now, if somebody flat out tell you they are teaching failure, all right, and perhaps you worded it in a way that has an irony to it, but if somebody telling you flat out they're teaching you failure, why would you want to continue to listen with the intent to learn how to succeed? That statement in itself to me says that the person specializes in failures. And it doesn't give any indication that the knowledge that's being disseminated will propel you to a level of understanding how to succeed. And so for that reason, I'm gonna keep it moving. But I wanted to point that out. It's very important to take note, take a little judicial notice.
I've had far, far more failures that I learned from.
Give me an example of that. Touch on that a little bit, because I know we spent some time, years ago, and you talked a lot about, the pitfalls that are involved in this particular space. Could you kind of touch on that a little bit?
Well, there's pitfalls in the information that's provided to you. A lot of individuals in our space purport themselves to be very financially savvy, and they will come across that they have financially savvy legal counsel or accountant individuals that will provide you information that they're deeming as true, when in fact it could be false or fake. Well, based on your lack of understanding of instruments and being able to do a true deep dive compliance on information that you're provided, you really can find yourself in a difficult situation, even perhaps staring down a federal indictment if you're not, if you're not really understanding what you're looking at and you're presenting something to be real that is not. Early on in my journey in this, I had received a numerous amount of medium-term notes that were fake, fraudulently structured, with the intent that I would pay a fee to receive these notes into our account, and had people to go through extreme measures to try to make that happen with an upfront fee. Things of that nature is being provided documents that are not legal, and you find yourself being gullible because you really want this to happen. Kind of like in your space, there's a lot of information that's provided that makes an individual that's struggling financially gullible.
Right.
Documents that you can go and put stamps on.
That look official.
Correct, look official, and you find yourself trying to present this to the court house, or you're trying to present it to some bank officer to offset a debt, and these individuals just simply were regurgitating information that they've heard and selling it, and you find yourself again in a vulnerable situation. And in a vulnerable situation, we tend to make decisions that are not too favorable on our behalf. So going back to your question, even structuring private placement memorandums, there are factors that fall under SEC exemptions that even allow you to participate in this arena. And in participation, there's always safety mechanisms that are in place that cannot be ignored. And if they are ignored, you can find yourselves in difficult situations. So when dealing with bond structuring, corporate bond structuring, entity structuring, and tying those to private placement memorandums, there's documentation that is required that you can't overlook. And it only takes one document to be out of place to make a whole year's worth of work go down the drain.
Wow.
So compliance, deep compliance.
Yeah, it was compliance. And, we were discussing that. And that's what I noticed as well, is that compliance is a very, very important aspect to all of this. And, I noticed you said that it's kind of replete with a lot of fraud too. I can see how that could happen. We have a lot of individuals who come into the door who actually master the terminology.
Right.
Is that correct?
That's
they can
correct.
speak to
That's
speak.
correct. They can speak to talk.
They can talk to talk, but
talk.
they can't demonstrate it.
If you didn't go to the ER after a car accident, listen up. I got $96,000 for my accident in 57 days.
Demonstrate it.
No, you will not find individuals that can talk it and produce it. It's called the receipts. Especially in the space of individuals taking some of their personal certificates. I won't get into that because I'm never going to challenge people's methodologies or their structures that they're trying to pursue. What I'm saying is that in a square peg, when you're trying to bring a round peg and fit it into the DTC structure or private placement memorandum structures, they don't fly. But these individuals will tell you that they do. And you're saying, fair enough, I believe you. Just show me where you've gotten it to fit.
Exactly.
And then they'll say, well, I know such and such who did. But you're purporting it as successful, yet you can't show me how to find that success. And what I was sharing with the audience in the webinar yesterday is, aren't you tired of that? Let me show you a method that's real, that's structured through the SEC, through the DTC, through regulations that are real. And then as you look around you, as you're driving downtown or whatever your city is, or out in the suburbs, and you're seeing these subdivisions coming up, and you're seeing these commercial buildings coming up, and you're seeing all these things going up, and they're basically structured as private placement memorandums and bonds that are structured to do a capital raise. And so I'm challenging them and your audience now that they need to stop, understand this process, and start really looking around them and seeing that they too can do what these individuals are doing. And I challenge them, what was the difference in them and you?
Exactly.
And what did every one of them say?
They're doing it, and what we said, they're doing it, and you're not. That's it.
Not
That's
yet.
the only difference. Not yet.
And we're going to say not yet. And so what was so exciting about the individuals that was in the webinar was, again, their astuteness, their attention to detail, and guess what? Their willingness to adapt to methods that are real, to no longer chase these methods that come over in a hypothetical situation or a theoretical situation. Again, it's not an attack on their method, but what does it do for putting money in the pocket of your family, creating generational wealth, putting yourself in a structure? We had one of your callers who came and said, hey, I already have my PPM in place. I already have my bond structure in place. I just need to understand how to categorize it and how to put it. And we'll follow up with her to help her structure that. You had another individual who find themselves trying to structure their EV charging station business, who has tried to do a capital raise, but we suggested that he encompass his capital raise in other areas, and he had already gotten that suggestion, and I second that suggestion. So much that individuals were willing to take a whole new look at private ordering, private structuring, and take advantage of it.
This is some powerful information. I get the feeling that I'm on the chessboard, the world chessboard. In this game, it's like dealing with the way and the creativity that is involved in it is also attracted to me because you can creatively construct something as long as you can add value and demonstrate that value, and you can offer it to someone perhaps for,
Yes, absolutely. The creativity comes in this. The fact that as you're preparing a private placement memorandum, you do not have to. These are not documents that you place in the SEC. You're not regulated by the
private.
SEC because you're private. It's just that you're private. And the flip side to that is that your disclosures and everything that you're structuring has to have a clean exit strategy, has to have a default strategy, has to have a value strategy. And as long as you're exercising these documents and structuring them in a way that your buyer of your bond or the investor in your bond structure, if they are in agreement through an indenture agreement, everything is good.
Everything on the private side is about agreements.
That's right.
Yeah, agreements.
Four corners of the agreement.
The four corners of the document, and that's what we're going to be showing all of you in the mentorship program. Going to be walked step by step by Mr. Brewer, so you can see how this actually goes, and you can structure this yourself. It is. How long is it? The course is going to be what?
The course is going to be 8 weeks. We're launching the course for your group last night, and I thought about it. I'm going to be consistent in creating 8-week courses. And during that period of time, we're going to analyze what it is you want to create in terms of, let's say it's a development. We've heard several individuals on the webinar that had projects that they wanted to structure, get funded, and raise capital for. And they pretty much had all their thought process and ideals in order. But now, how do we take private placement memorandum and the Reg D 506 B and 506C, and how do we structure it within what they're trying to do? So we're taking a legal, private ordering structure that's regulated and put in place by rules, regulations, and procedures, guidelines to follow. What better way?
because the issuer was able to show his offering documents. It wasn't technically a PPM in that case, but same type of disclosure document that said, the targets might not come true. You might make less, you might make more, when nobody can predict the future. And the investor signed it, and there's nothing he can do now. So, very, very, very important to have these documents, have them tight, and be able to use them in case a investor decides to be litigious. Okay. So what should be in a PPM? Now, when I say PPM or private placement memorandum, generally I'm using this as an umbrella term to mean the entire package of offering documents. So when you get what I call a PPM, there's going to be several parts. And the first part is the actual PPM itself. So you're going to get 100, 150 pages of documents. The PPM itself is really only like 40 or 50 pages generally. And then everything else will be attached as exhibits. You'll have an operating agreement, or as we call them in Texas, a company agreement.
Let's start this over.
Hi, everyone. My name is Richard Robinette. I'm an attorney at Crowdfunding Lawyers. And this is part of our weekly webinar series. And this week, we're going to be talking about private placement memorandums and what's in a private placement memorandum and all the exciting things that go with private placement memorandums. Just a little bit about myself. I'm an attorney. I've been practicing law for almost 10 years now. Been doing securities law for about the last 6, along with my partner, Nate Dodson, who took over this firm with me. I worked for him at another firm for many years before that. And we're rolling on and ready to help everyone with their securities offerings, their investment packages, and all that fun stuff. So, cool. Let's get right into things. First of all, because we're lawyers, we have to do a disclaimer. So here's our disclaimer. This is not legal advice. We're not creating an attorney-client relationship by doing a webinar. That would be silly, and you'd be paying us a lot more if we were giving you legal advice. So this is purely for educational purposes. It's not intended to be complete. It's not intended to be perfect. It's just to give you an idea of what's going on. Please consult with your professional advisors before participating in any investment opportunity. Thank you very much. Let's roll on. So, what are private placement memorandums? Well, private placement memorandums are memorandums for private placements, but that's not a very useful definition. So let's start with what is a private placement. And a private placement is very simply an offering of securities that's not available on the open market. So most of us, when we think about buying securities, we're thinking about stocks that are on the New York Stock Exchange, and we're thinking about mutual funds that we get with our Charles Schwab broker. We're thinking about CDs. We're thinking about things of that nature, getting on Robinhood and short squeezing GameStop. Those are public securities. These are securities that are not public. They're not available on Robinhood. They're not on any trading platform. They're not, on NASDAQ or anything like that. You can't go to a bank and buy them. These are only offered privately. So an important thing to know about private placements is they're not registered with the SEC. The SEC does not look at them ahead of time, does not approve them. The SEC gives certain exemptions from registration, and that's what the issuers of these securities are relying on when they put together these private placements. Oftentimes, these are called exempt offerings or unregistered offerings because they are exempt from registration with the SEC. And an important thing is that investors generally have a limited ability to resell these. These are called restricted securities. So there are very strict rules on being able to turn around and resell the securities you buy. You're not going to be day trading these kinds of securities. Generally, there's some exceptions, but generally, once you're in a deal, you're in the deal. If the deal goes 10 years, your money's tied up in the deal for 10 years. So if you invest in private placements, please be willing to tie up your money indefinitely, because some of these deals can go on a very, very long time. and it's very difficult to get out of them once you're in. Okay, private placements. A lot of people haven't heard of them, but they're actually really, really, really big business. So to give you a little bit of perspective, if we just look at, where we normally would buy our securities, New York Stock Exchange has about 2,800 stocks available. The NASDAQ has about 3,300 stocks available. Regulation D offerings, and Regulation D is one of the places where private placements are offered. Actually, the majority of private placements come under Regulation D. In 2017 alone, there were 37,785 Regulation D private placements available. So this is a big portion of the investing world, so to speak. Just a couple of fun facts, and this is all from 2017 because it's the most recent year that I have statistics for, but it's recent enough to be meaningful still. More than $3 trillion, it's not a typo, more than $3 trillion was raised in unregistered securities offerings in 2017. About two-thirds, not quite two-thirds of that, 1.85 trillion was raised in Regulation D offerings. Now, your average offering size on Regulation D was $32 million, and the median was $2 million. So these offerings come in all kinds of sizes. There's some people that are only raising a few $100,000. There are people that are raising tens and even hundreds of millions of dollars through Regulation D private placements. Another interesting thing is only 9% of Reg D investors in 2017 were unaccredited. And unaccredited is a term we use for people regarding their suitability or their ability to buy certain securities. And if you want to know more about accredited versus unaccredited investors, see our last webinar, my last webinar that's on YouTube about structuring syndications. And I talk a lot about the difference between accredited and unaccredited investors, changes in the definitions. Hopefully this number is going to go up. The SEC has been liberalizing the rules a little bit incrementally recently. They've allowed more people to be considered accredited, which gives them access to more offerings. And they've relaxed, for instance, Regulation D, Rule 506B, which previously allowed only 35 unaccredited investors. Now it allows 35 unaccredited investors in any 90-day period. So it's possible for more unaccredited investors to get in some of these deals. They've also raised the limits on other rules or other regulations that allow unaccredited investors. So there are more opportunities coming up for the little guys, so to speak, to get into some of these private placements. So hopefully it's not going to be such a country club, good old boys club, rich people's game. Hopefully this is going to be opened up more and more to the Joe Everyman investor. Okay, so we know what private placements are. What are private placement memorandums? Or is that memoranda? Memoranda? I actually looked it up. And Webster told me that either way is fine. Call it memorandums, call it memoranda, whatever. If you have strong opinions about that and you're watching it on YouTube, please put it in the comments, and we will gladly ignore your rage there. All right, so what are private placement what is a private placement memorandum? Well, a private placement memorandum is a legal document that describes material facts about a private securities offering. And I want to emphasize that it's a legal document, it's a securities document. This needs to be prepared by a securities attorney. And I want to take this opportunity to remind everyone that the internet is not a securities attorney. And some of you guys out there, I know, I read PPMs all the time. I read them for a living. And some of you guys are cobbling together crap you found on the internet, and we can tell. And that's a great way to get yourself in trouble with securities regulators. Don't take that risk. You're raising hundreds of thousands, if not millions of dollars. Pay a little bit to have a bona fide securities attorney draft your offering documents. Okay. The PPM, private placement memorandum, provides investors with the information they need to make an informed decision. The last thing you want, if you're an issuer, is to have an investor claim that they were not well informed or that they were not given adequate information. So the PPM is a place where we're going to disclose all kinds of things, anything and everything about the deal, so that nobody can claim ignorance if they decide to get in a dispute with you. And that's important because as an issuer, this is your first line of defense. This is your protection against baseless claims that you misled investors. And if you mislead investors, we can't help you. But if you've been above board and an investor gets mad at you anyway, maybe your returns fell a little short of what you projected. Maybe you even lost a little bit of investor money. Maybe operations or construction or whatever project you're working on took longer than you expected. Investors get mad and investors sue. And when they sue, your first line of defense is that PPM, where you're going to say, look, I told you this. I told you this. You agreed that you read it. Go away. There was actually a really high profile class action suit dismissed just the other day based on this exact same thing. The investor it's actually kind of funny. The investor, invested in this deal, and the deal was targeting 5% cash on cash returns for the investors. Well, the guy only made 4.95% cash on cash. And so he sued. And the suit just the other day was dismissed as being without merit. And the reason it was dismissed is because the issuer was able to show his offering documents. It wasn't technically a PPM in that case, but the same type of disclosure document that said, the targets might not come true. You might make less, you might make more, when nobody can predict the future. And the investor signed it, and there's nothing you can do now. So, very, very, very important to have these documents, have them tight, and be able to use them in case a investor decides to be litigious. So what should be in a PPM? Now, when I say PPM or private placement memorandum, generally I'm using this as an umbrella term to mean the entire package of offering documents. So when you get what I call a PPM, there's going to be several parts. And the first part is the actual PPM itself. So you're going to get 100, 150 pages of documents. The PPM itself is really only like 40 or 50 pages generally. And then everything else will be attached as exhibits. You'll have an operating agreement, or as we call them in Texas, a company agreement. Or if it's a corporation, you'll have bylaws, or if you're investing in a debt offering, promissory notes, whatever governing documents surrounding the investment, those will be and frankly, the operating agreement, the bylaws, those things, in my opinion, are more important than the PPM itself. The PPM really only matters while the securities are being sold. That's it kind of plays a limited time role, and once the company is done raising money, the PPM doesn't really do anything else. But the operating agreement governs the operations of the company from that point forward. So if a deal lasts 5 years, 10 years, 20 years, the day-and-day relationship between the investors and the management or the issuers, that's all going to be governed in the operating agreement. So it's very, very important that you read that. They'll also include a business plan, pro forma. So even though the PPM or the offering package is not a marketing piece, its purpose is not to convince investors to invest. It will generally include a business plan to show here's what we plan to do, pro forma projections of how much money we expect to make over time. Pro forma is Latin for bullshit. But this is what we think investors are going to make. It's going to be a 15% IRR. It's going to be an 8% cash on cash return every year or whatever. That's all lined out in the business plan. That's generally where we see like the flashy pictures and the charts and the maps and the colors and everything, trying to draw your eye and get you to pay attention to that and ignore all the doom and gloom that's in the PPM itself. And then finally, there's going to be a subscription booklet or a set of subscription documents for the investors to fill out if they want to get into the deal. And in the subscription booklet, you're going to have a suitability questionnaire, because not all of these deals are suitable for all investors. Not all investors are suitable for these deals. So some deals are limited only to accredited investors. So the suitability questionnaire is going to ask you several questions to ensure that you're accredited. Some deals you even have to have that verified by a third party. Deals that allow unaccredited investors are still going to have suitability questions, about your experience, about your education level, about your, investing history. What other things have you invested in? Basically feeling out whether you as an investor, or whether the investor knows enough to know what they're getting into, that they are sophisticated enough to participate in the offering. Now, if you don't have a lot of experience, you don't have, you've never done business, you've never really invested in anything, you can still get into a lot of these deals with an investor representative, so someone who can basically lend you their sophistication. And I talk about that in my syndication video that is now living on YouTube. So check that out if you want to know more. And then finally, you're going to have a subscription agreement, and that is the document that the investor signs saying, yes, I read the PPM, yes, I read all the exhibits, yes, I understand the risks, and yes, I still want to invest. I'm going to put in $50,000, $100,000, whatever the investment is. Sign here. The subscription agreement usually also includes a counterpart signature for the operating agreement, saying, yes, I agree to be governed by the terms of the operating agreement or by the bylaws of the corporation. So you are signing up to be a member of the LLC or a stockholder in the corporation, and I agree to all these terms that were given to me. So all of that together generally is what makes up what I call the PPM, what makes up the offering documents in a private placement. Okay, that's real great. That kind of is the table of contents. Let's dig just a little deeper and talk about substantively what is going on in a PPM. So basically a PPM answers the 5 W's that we all learned in school: the who, what, when, where, and why. So who's involved in the offering? What is it that's actually being offered? Is this a debt offering? Is it an equity offering? Am I buying stock? What are you selling me? When does everything happen? How long am I going to be in this deal? Is this a deal that's going to last a year? Is it going to last 10 years? When am I going to get my money back? Those kinds of questions we need answered. Where does the money go? Once I invest $100,000 in your deal, what happens to it? Who gets paid what? And how does the money flow throughout the entire company? And then why is the company raising money like this in the first place? What's the story behind the offering? What's the plan? And we're going to break these down a little more granular as we go, but kind of what's the overall picture of what we're doing here. And then I'll add a sixth W, or sixth and seventh W. What could possibly go wrong? Very, very important question to ask, and it's not a question that you ask to brush off, because things do go wrong. Not everything is rainbows and unicorns all the time, and as an investor, you need to be aware of that. As an issuer, I'm losing my voice here. As an issuer, you need to think about the things that could go wrong and make sure that that's adequately disclosed to your investors, so there's no surprises coming down the line. All right. So let's start with the who. Great band. What company is selling the securities? So this is going to be, Joe Blow Capital Fund Number 1 LLC. Where was it formed? Delaware, Wyoming, Nevada. Who's in charge of the management? This one's really important. Who's the person behind all of this that's making things happen? Do you know them? Do you trust them? Who are the key principals? Who are the other players in the deal? Who are who's guaranteeing loans on behalf of the company? Who is consulting the company? Who are the professional advisors? Who else is what we call sponsors? Who are the sponsors of the deal that are making things happen behind the scene? They may or may not. So a lot of times there's other people who are making things happen. Maybe people that are raising money, maybe people that are consulting on, if it's a real estate deal, property searches, or consulting on software development or whatever it is that we're raising money for. So we should have all those people listed. We should have their bios or a resume of those people. You may have information if they've done this stuff before. You may have past performance information about previous deals and how much their deals made or didn't make. So you can kind of see their track record. There'll always be a disclaimer: past performance does not equal future results. But it's kind of nice to know whether someone has a track record, right? And then skeletons. And I'm speaking to the issuers now, the people that are wanting to do these offerings. You probably don't want to disclose your skeletons. You probably, if you have stuff in your past, maybe you declared bankruptcy at one time. Maybe you got in trouble with securities regulators or other regulatory bodies in the past. You probably don't, you're probably not too proud of that, right? But it's not the end of the world, and it is something that investors need to know, and it's best practice to disclose. If there's ever any doubt whether investors need to know something about you or about your past, err on the side of disclosing it. We don't have to make a big deal about it, but we're also not going to brush it under the rug. Here's what happened. These are the facts. Invest if you want, don't invest if you don't want, and we can all still be friends. And then the last who I have is who's allowed to invest in the deal. Is this only for accredited investors? Is it only for sophisticated investors? Is it only for people that already know the issuer? Or is it for, anybody? Or if it's, certain types of offerings, you have to be qualified clients, or you have to be, have an even higher standard for who you let in. So, but the PPM is going to tell you, who's this deal for? And then, are you one of those people? Yes or no. If you're not, throw in the trash. Okay. What type of security is being sold? Is this preferred equity, where I'm going to get a percentage on my money every year? Is this common equity, where I'm just going to share in profits and growth? Is this debt, where I'm going to be a lender and I'm going to hold a note that the company owes me payments on over the years? What business activity is being funded? What are we doing? Are we buying a specific piece of property? Are we just raising money to buy real estate in general that we haven't identified yet? Are we a tech startup? Are we a medical startup? Are we an existing company that's had operations for years and just needs more money for whatever activity? What is this for? Moving on to when. And when does the offering wrap up? Some offerings are only going to be open for 90 days, some 6 months. Some are going to be open indefinitely, and they will be raising money for years and years and years and years. A lot of lending funds, for instance, which just raise money forever. And money comes in, they make loans, and loans get paid off. Sometimes they pay off investors and then they're out of the deal. Sometimes they keep their investors in. So when does all this stuff happen? When can the issuer start spending the investor money? Now, this one's important. So when you have an offering, you're going to have upfront charges. You're going to have the expenses setting up the company. You're going to have the expense of putting together a securities offering. Real estate, you're going to have due diligence expenses on a piece of property. You're going to pay for inspections. You're going to pay for environmental reports. You're going to do all kinds of due diligence. You're going to pay loan application fees. A lot of things that cost money at the front end of these businesses. And a good question for an investor to ask is, well, when I put money in the deal, are you going to immediately spend it on those things? Are you going to immediately reimburse yourself for those expenses? Or is there a threshold amount of money you're going to raise first before you start spending my money? Because if you think about it, if they only raise a little bit of money and all that money goes to startup expenses, then there's no business and the investor's not going to get anything in return. So most deals will have a minimum investment amount that says, we will not start operations. We will not touch the investor money. Breaking impounds is the term they use. We will not break impounds until we have raised $2 million or $5 million or whatever it is. And then once they've raised that threshold, then they are allowed to use the money, start paying off expenses, start operating, and start putting the investor capital to work. If they don't raise that minimum amount by a certain deadline, and the deadline will be stated as, say, 6 months. If in 6 months we haven't raised $2 million, we're just going to return all the investor money, no questions asked. Have a nice day. So when can they start using your money? When will construction or rehab project or whatever goal the company has, when is that going to be done? How long is it going to take to build the apartment complex? How long is it going to take to develop the software? What are your expectations for that? When can investors expect to see dividends or distributions? Deals vary quite a bit. So for instance, you might have an issuer that's going to buy fully leased up Class A, brand spanking new multifamily apartments. And as soon as we close, like that month, we're going to have cash distributions to investors, and we're just going to start divvying up cash basically from day one. Another deal might be buying, a burnout. And, it's going to take 2 years to get all these units back online and leased up and actually making money. And so we're not going to give any distributions to investors for that time. So the PPM is going to disclose, when can I expect to start making money on this deal? Some deals you won't make any money until the investment's sold off and the company's wound down, and then just at the very end they distribute. Here's your initial investment and here's your profit, and have a nice day. It varies. When can investors expect to receive a return of capital? So, again, and I'm talking a lot about real estate because real estate's kind of the pond I play in for the most part. And, if I'm buying a piece of property, I may expect to refinance that property in 2 years. And, out of the refinance proceeds, I'm going to give the investors back their initial investment. Or it's maybe a property I'm not going to refinance. I'm going to buy this thing. Maybe I'm going to buy it cash, and I'm just going to hold it for 10 years and then sell it. And so you won't receive a return of capital. You might receive cash flow along the way, but you won't receive a return of your initial capital until the end. So that's an important win. When will the company cease operations and wind down? Some companies intend to run forever. Some companies are just going to buy a property, operate it 5 years, sell it, and that's the end. And they're going to just close the doors. Those are expectations that are going to be set in the PPM. Now, I will say, virtually always you'll see a qualifier in there that says this is subject to market conditions. If the economy is in the tank in 5 years, we ain't selling the property. We're going to hold on to it until we have brighter skies or whatever, or bluer skies, whatever the phrase is. All right. Where does the money come from? Is this project all investor money, all capital contributions through this offering, or is there maybe a lender? Is there Fannie Mae going to come and lend a bunch of money on this too? Are there other securities offerings going on at the same time? Where's all the money coming into the company, and then where does the money go? And every PPM is going to have a use of proceeds section, which should tell you exactly where the dollars coming from investors are going to end up. So how much of it's going to go to selling commissions to broker dealers? Some deals, you might have a broker dealer making 6 or 8% off the top. The investors need to know that, only 94% or 92% of their money is actually going to reach the project because they're selling commissions. How much of it goes to the attorneys putting the offering together? How much goes to the managers and fees. And fees are one place where a deal can get eaten up. If you've got a deal that has, ridiculous fees, where we've got a fee for, every time we blink, the manager collects another fee. You might want to sit down, if you're an investor, you might want to sit down with a calculator and figure out, how much these fees weigh down the returns you're going to make. Likewise, as an issuer, you need to stress test your fees and make sure that, I know you want to make a lot of fees, and you should make fees for the services you provide. At the same time, you need to make sure that, your investors are reasonably going to expect a good return as well. So, you see some deals, where it's, I got an acquisition fee, a disposition fee, a finance fee, a asset management fee, a property management fee, I can fog a mirror fee, a construction fee. And at the end of the day, there's like nothing left for, there's no room left for any profits. And that's not a good thing. The flip side of that, I've seen deals where like a guy's just doing everything out of the kindness of his heart, and he does all this work and does all this due diligence and doesn't make any money. And that's pretty ridiculous too. So you got to stress test your deals, find the balance, so that you're not overcharging, you're not undercharging. And then as a passive investor, make sure you understand how fees are being earned, where that money's going. Do your homework. How much money is going to capital expenditures? How much money is being used for operations? Is any money being held in reserves for a rainy day? Are there any other capital requirements of the company? Those are things. So all that should be outlined in a use of proceeds. And then finally, not finally, but everyone's favorite topic, distributions. How much money am I going to get back as an investor? When am I going to get it? What's my percentage? How is it divvied up? That's all going to be described in a distribution section. And usually the PPM is simply going to summarize distributions, maybe in plain language. And then the actual distributions, the piece that's going to govern, is actually in that company agreement, that operating agreement that talks about distribution. There'll be a distribution section that says, when we make profits, the first thing we're going to do is pay, this class of investors 6% return. The second thing we're going to do is, split whatever's left 60-40 or 50-50 or whatever. And it just kind of outlines, how does the money, how does each dollar get broken down, being distributed. Okay. And then there's probably going to be a discussion of taxes and tax risks, the tax treatment of the company. Really interesting reading material, but an important thing to disclose if you're an issuer is the possibility of phantom taxes, where the company may make profits, but it maybe holds those profits, doesn't distribute them to investors, but the tax burden goes to all the investors. So as an investor, you may have taxes to pay on profits that you haven't actually seen come into your bank account yet. So anyway, there'll be a discussion of all of that somewhere in the PPM. All right, and then the why. What is the story behind this investment? This part of this gets into a little bit of marketing, because a compelling story, it helps people want to invest. Why is the company raising investor funds? Are we a brand new company? We need startup capital. Are we an existing company that's doing a new venture? What's the point of this? If it is an existing company, what do current operations look like? What do current financials look like? Now, a lot of these are brand spanking new companies. We formed the company for no other reason than to do the offering, so there's not going to be any financial history. But if it's an older company, you'll see, a financial picture of the company, and then again that business plan, that nice glossy, plan with photos and graphs and smiling people and lots of color, and it's, that's there to tell the story of the investment. All right, and then my last W here, my last two W's, what could possibly go wrong? And probably one of the biggest sections in any private placement memorandum is going to be the risk factors. There's going to be risk factor after risk factor after risk factor. And the risk factor section is really a brainstorming exercise where the issuer and their attorney sit down and think of everything that could possibly go wrong in this deal. How many different ways could your money be lost? How many different bad things could affect performance? Everybody now has got a COVID-19 risk factor, talking about how, an eviction moratorium could affect investor returns. Flooding could affect investor returns. There might be an earthquake. There might be a drop in the stock market. There might be massive unemployment. Amazon might close their big warehouse down the street. If this is done right, basically they're going to give off the impression that this is the most absurdly dangerous, speculative, risky investment ever, and you might as well just set the money on fire. That's a good risk factor section. And it sounds terrible because it sounds like you're trying to scare investors away. But, again, if you're ever in a dispute and you ever have to go to court and defend yourself against an investor that's mad at you for whatever reason, you're going to want that strong risk factor section to hold up and say, I told you so. I told you this could happen. I told you all the risks and you chose to invest anyway. So we want a good, solid, beefy risk factor section in our documents. All right. Speaking of things that can go wrong, you're going to multiply the chance of things going wrong if you don't pay attention to what's actually in these documents. So if you're a passive investor, please read your documents before you invest. You're about to put $25,000, $50,000, $100,000 or more into an investment. Set aside 3 or 4 hours to actually read the offering cover to cover. I know it's boring. I know it's legalese. I know it's a little hard to understand. It's not a Grisham novel. But do take the time to read it. And if you're an issuer, please read your documents. Don't just trust that your attorney, is going to give you their stock thing and it's going to be perfect. What's good for one client is not necessarily good for another client. And how one client chooses to do things in their deal is not how another client does. So when your attorney gives you your documents, read the things, ask questions, ask for changes, or ask why things are done a certain way, or if there's a better way or something that's more compatible with how you want to do business. And also, this is a second set of eyes, because believe it or not, I hate to admit it, but attorneys make mistakes. And if you're the issuer, you're the first line of defense against those mistakes when you're delivered your drafts of your PPM. So read the thing. I'm just going to show you a couple things that I've found. These are all examples from actual PPMs that I've reviewed. Things that are problematic. Some are problematic for the issuer, some are problematic for the investors. But things that are important to have caught. And if you were investing, I hope you would have noticed these things. Or if you were issuing, I hope you would notice these things. So first thing, and I see this all the time, where what's described in the PPM and what's put in the operating agreement don't match. It's talking about people that, cobble their, do a DIY PPM and cobble a bunch of crap together from the internet. Like that's notoriously mismatched, because they'll get the PPM from one place and they'll get the operating agreement from some other website, that they found somewhere. And the two are simply not compatible. So an example I actually saw not too long ago was this. We had a PPM. It says the units carry a sharing ratio of 80%. So the discussion was the profits were going to be split 80-20 with the investors. Okay, that's a typical deal. That's fair, right? But if you read the actual operating agreement, it actually says the distribution of cash may be undertaken in such fashion as the manager determines with respect to the amount to be made to each member. So while the PPM promised an 80-20 split, what the investors actually got was, well, the manager can pay you whatever he wants, and too bad. Definitions. Your PPM and your operating agreement probably both have a definitions section. And definitions is a great place for attorneys to be kind of weaselly, because what we can do, I'm not advocating this, so I wish attorneys wouldn't do this, but what is often done is take a common term and define it in a strange way or a different way or a sneaky way, and then use that term throughout the document. So the only place you would ever catch that this term actually means something else is in that definition section. So for instance, required interest is a term that's commonly used in these deals. And what required interest is what's the threshold to pass a vote? If our members are going to take a vote for the company to do something, do we need a majority? Do we need 60%, 75%, whatever? So the required interest will be whatever percent we need to pass a vote, right? So this deal, and again, this is from an actual deal, so the required interest shall mean a majority of the units. Units are like the shares of stock, plus the affirmative vote of the manager. So what they've done is make it where if the manager doesn't agree to go along with whatever the members vote, it doesn't matter how big the vote is. You could have a unanimous vote of the investors. And if the manager says no, well, he's got a veto on everything. So for instance, maybe there's a provision to remove the manager for underperforming. And the investors get together and say, we want to kick this guy out, get someone else in charge, and save the deal. Well, to get a required interest, the manager has to say yes. The manager's not going to vote himself out. So basically, any vote where the manager's interest is not aligned with it ain't going to pass. And that was very cleverly snuck into the definitions, and everywhere else just said required interest for this, required interest for that. So, bait and switch. So this was a deal where this was a syndication where they went to investors and they said, we're going to buy this one specific piece of property at 123 Main Street. It's a 150 unit apartment complex or whatever it is. And so this is what we're raising money for. That's a syndication. And in my other video on how to structure syndication, I'm talking about the difference between syndications and funds. In a nutshell, funds are just raising a pool of money and then we'll go figure out what we're going to do with it. Whereas a syndication is we are going to buy this thing. Well, here they slipped into the PPM. If the company determines that the target property is not suitable, it may terminate any purchase and sale agreement and renew the search for another target property. Subscribers' deposits, which means investor money, will be used for expenses of the company for the additional searches. So if they choose to, at any time, for whatever reason, not buy this property they promised everybody, all of a sudden we've turned our syndication into a blind pool and investors don't know what they're actually getting into. Maybe this was an A-class apartment they were saying they were going to buy, and now we're going to go check out this mobile home park, or we're going to go check out, some single family duplexes or something. And so the investors frankly have no idea what they're getting into if the company decides not to buy this one property. All right. Who's the boss? Control. So you'll see different provisions for removing a manager or for kicking the issuers out of a deal. And, some of them require maybe a really high threshold. Maybe you got to get 75% of the investors to vote on it, or maybe there's a time period to cure, or whatever. There's a lot of hurdles generally. It's very hard to remove a manager. And then I came across this one day. This was in a company agreement and says the manager may be removed at any time for any reason by a majority vote of the Class A members. Class A members are just the investors, not including the manager or any affiliates. Okay, so we have a simple majority vote. It's just of the investors. The manager doesn't get a say, doesn't get a veto. Wow. That's a really lax provision there. Mm-hmm. And it seems really easy to just kick the manager out if he's not doing a good job. Then it says, upon the removal of the manager, a successor manager shall be appointed by a majority vote of the Class B members. Guess who the Class B members were? It was the manager and all of its affiliates. So you vote the manager out, and the manager votes himself right back in. All right, so the bottom line of all this is read everything. Pay attention to what's in your documents, and make sure there's no surprises. And that's all I got. I'm going to move into Q&A, and hopefully Nate Dodson is on the line. Hey, there he is. I can't hear you. I'm gonna take care of some technical difficulties here.
Hold on.
If you're watching this live and you have questions, please put them in the Q&A section. If you're watching this on YouTube, put them in the comments. We'll try to follow up. And
Okay, we're going to stop right here and do a little commentary on what we've already viewed and heard and what has been demonstrated in the broadcast. Some very good details concerning private placement. He has not gotten to a point of giving us any information as to brokering the deal, but people need to understand the long drawn out process of drafting the deal first, okay? Because people need to understand when they're trying to copy off of what you're doing that some of the things that people have constructed have taken a lot of time and effort to construct whatever type of intellectual property, goods, business ideas, whatever they have in that regard. For people to come along and draft, just go to their favorite AI and just draft up documents purporting to have come up with some grand idea that they have copied off of someone else's process or methods or business niche, okay, and therefore stolen the potential of market space that that person would be filling, and doing so without any detailed knowledge as to what the idea was even about. I see that going on a lot on YouTube. People are not realizing when you place your YouTube channel in a specific market and you tag your content to draw viewership and subscribership to your channel, you're then shifting the market to patronize your product or content, and that in itself is a private placement. We've already gotten a YouTube channel that is a private placement. You just have not structured it in that way. But it is indeed a private placement. And so that's an agreement that you have between you and YouTube, partnership, that you will create content and they will curate it and distribute it in the markets that they can reach or that they can create for you to optimize your online presence. As well, consequently, you may experience some benefit in the private, as as far as you make your call to action, uh, telling people to patronize your website or book or any other merchandise materials that you have for sale. Okay, if you have a service that you're offering for sale, you can then create content with a call of action. Call of action means you get somebody to do something, take action and do something. Subscribe or uh, purchase something, or you say, check out my website. Okay, you want to drive traffic so that you can get your viewership uh, numbers up of how many people are interested in the content that you are providing. And so when you do that, you are in a position to market that and sell that website, or you can what do you call that? Get investors or sponsors in to your channel. Um, and so that is dependent upon what your goals are for creating, all right, for building the business, whatever type of business it is. Now, he's speaking about private placements on real estate investors because that is a common, oh, too common uh, market. In other words, everybody doing that. It's like it's nothing special about that kind of offering. Nothing special about that kind of offering. They're everywhere. You see the signs. We'll buy your uh, house, no questions asked. Type of shit. You call the number and they don't even respond well. Uh, you got all kinds of shenanigans going on. Sometimes those advertisements is just to get build their numbers of people interested in that type of service, and then they then use those calls uh, to market um, to investors and say we've had uh, 10,000 calls in 2 weeks for this type of. So if it's a startup, then offering the service um, is not in vain because they can then actually get the investors to bite, to invest. Okay. So we're going to stop right there. We've done quite a bit today, and we will proceed with this in giving us some more further detail about private placements. But we want to just first get some idea of what's going on in the picture.